Privacy law refers to the laws which deal with the regulation of personal information about individuals which can be collected by governments and other public as well as private organizations and its storage and use. Privacy laws are considered in the context of an individual's privacy rights or reasonable expectation of privacy. Classification of privacy laws. Privacy laws can be broadly classified into general privacy laws that have an overall bearing on the personal information of individuals and affect the policies that govern many different areas of information. Specific privacy laws that are designed to regulate specific types of information. Some examples include communication privacy laws, financial privacy laws, health privacy laws, information privacy laws, online privacy laws, privacy in one's home. International Legal Standards on Privacy, Article 8 of the European Convention on Human Rights, which was drafted and adopted by the Council of Europe in 1950 and meanwhile covers the whole European continent except for Belarus and Kosovo, protects the right to respect for private life. Everyone has the right to respect for his private and family life, his home and his correspondence. Through the huge case law of the European Court of Human Rights in Strasbourg, privacy has been defined and its protection has been established as a positive right of everyone. Data privacy laws are converging in the EU, helped by the national data protection authorities and the Data Protection Directive adopted in 1995. Article 17 of the International Covenant on Civil and Political Rights of the United Nations of 1966 also protects privacy. No one shall be subjected to arbitrary or unlawful interference with his privacy, family, home or correspondence, nor to unlawful attacks on his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. Privacy laws by country. Australia equals. The current state of privacy law in Australia includes federal and state information privacy legislation, some sector-specific privacy legislation at state level, regulation of the media and some criminal sanctions. The current position concerning civil causes of action for invasion of privacy is unclear. Some courts have indicated that a tort of invasion of privacy may exist in Australia. In 2008, the Australian Law Reform Commission recommended the enactment of a statutory cause of action for invasion of privacy. Brazil equals. A Brazilian citizen's privacy is protected by the country's constitution, which states, the intimacy, private life, honor and image of the people are inviolable, with assured right to indemnization by material or moral damage resulting from its violation. Canada equals. In Canada, the Federal Personal Information Protection and Electronic Documents Act governs the collection, use and disclosure of personal information in connection with commercial activities and personal information about employees of federal works, undertakings and businesses. It generally does not apply to non-commercial organizations or provincial governments. Personal information collected, used and disclosed by the federal government and many crown corporations is governed by the Privacy Act. Many provinces have enacted similar provincial legislation such as the Ontario Freedom of Information and Protection of Privacy Act which applies to public bodies in that province. There remains some debate whether there exists a common law tort for breach of privacy. There have been a number of cases identifying a common law right to privacy but the requirements have not been articulated. In Eastman v. Canadian Pacific Railway and Privacy Commissioner of Canada, Canada's Supreme Court found that CP could collect Eastman's personal information without his knowledge or consent because it benefited from the exemption in paragraph 7(1)(b) of PIPEDA, which provides that personal information can be collected without consent if it is reasonable to expect that the collection with the knowledge or consent of the individual would compromise the availability or the accuracy of the information and the collection is reasonable for purposes related to investigating a breach of an agreement. China equals. Computer Processed Personal Information Protection Act was enacted in 1995 in order to protect personal information processed by computers. The general provisions specified of the purpose of the law, defined crucial terms, prohibited individuals from waiving certain rights. France equals. France adopted a data privacy law in 1978. It applies to public and private organizations and forbids gathering sensitive data about physical persons. The law is administered by the Commission Nacional de l'Informática y des Libertades Copyright S, a dedicated national administration. Greece =, 2 Greek laws relevant to privacy are 57 AK and 2472/1997. As regarding photography, taking a picture of a person in a public space requires consent. Taking a photo or video of someone or drawing them in a painting constitutes an illegal act by itself according to Article 57 of the Greek Civil Code, even without any publication of the resulting photo, video or drawing. The law assumes that consent has been provided silently if the depicted person has been paid for the photography session. The law also provides some exceptions for persons of contemporary history. Furthermore, the Law 2472/1997 also applies in many circumstances, even in photographing political rallies in public places or in photographing the police. Greece also requires photographers to obtain a government permit before photographing people participating in political protests in public places. Publishing pictures of a person in a public space requires consent. The publication of photographs of identifiable police officers beating civilians in public places may be against the Law 2472/1997, and as such these images should be turned to the authorities for review. Commercial use of a published picture of a person in a public space requires consent. India In June 2011, India passed a new privacy package that included various new rules that apply to companies and consumers. A key aspect of the new rules requires that any organization that processes personal information must obtain written consent from the data subjects before undertaking certain activities. Application of the rule is still uncertain. Previously, the Information Technology Act, 2008 made changes to the Information Technology Act, 2000 and added the following two sections relating to privacy: Section 43A, which deals with implementation of reasonable security practices for sensitive personal data or information and provides for the compensation of the person affected by wrongful loss or wrongful gain. Section 72A, which provides for imprisonment for a period up to 3 years and/or a fine up to Rs. 5,000,000 for a person who causes wrongful loss or wrongful gain by disclosing personal information of another person while providing services under the terms of lawful contract. Japan Act on the Protection of Personal Information was fully enacted in 2005 for the purpose to protect the rights and interests of individuals while taking consideration of the usefulness of personal information. The law applies to business operators that hold the personal information of 5,000 or more individuals. Mexico In July 5, 2010. Mexico passed a new privacy package focused on treatment of personal data by private entities. The key elements included were, requirement of all private entities who gather personal data to publish their privacy policy in accordance to the law. Set fines for up to $16 million MXN in case of violation of the law. Set prison penalties to serious violations. New Zealand In New Zealand, the Privacy Act 1993 sets out principles in relation to the collection, use, disclosure, security and access to personal information. The introduction into the New Zealand common law of a tort covering invasion of personal privacy at least by public disclosure of private facts was at issue in Hosking v Runting, and was accepted by the Court of Appeal. In Rogers v TVNZ Limited, the Supreme Court indicated it had some misgivings with how the tort was introduced, but chose not to interfere with it at that stage. Complaints about privacy are considered by the Privacy Commissioner. Russia Applicable legislation, Convention for the Protection of Individuals with regard to automatic processing of personal data, signed and ratified by the Russian Federation on December 19, 2005. The law of the Russian Federation OE on personal data as of July 27, 2006 No. 152 FZ, regulating the processing of personal data by means of automation equipment. It is the operator who is required to comply with that act. As a general rule, consent of the individual is required for processing, that is obtaining, organizing, accumulating, holding, adjusting, using, disclosing, impersonating, blocking or destroying of his personal data. This rule doesn't apply where such processing is necessary for performance of the contract, to which an individual is a party. Data protection principles and legislation in the Russian Federation, online database of the Russian laws, Federal Service on Supervising in the Sphere of Communications, Information Technology and Mass Media. United Kingdom equals. As a member of the European Convention on Human Rights, the United Kingdom adheres to Article 8 ECHR, which guarantees a right to respect for privacy and family life from state parties, subject to restrictions as prescribed by law and necessary in a democratic society towards a legitimate aim. However, there is no independent tort law doctrine which recognizes a right to privacy. This has been confirmed on a number of occasions. K. v. Robertson, Wainwright v. Home Office. United States equals. The right to privacy is not explicitly stated anywhere in the Bill of Rights. The idea of a right to privacy was first addressed within a legal context in the United States. Louis Brandeis and another young lawyer, Samuel D. Warren, published an article called The Right to Privacy in the Harvard Law Review in 1890, arguing that the U.S. Constitution and common law allowed for the deduction of a general right to privacy. Their project was never entirely successful, and the renowned tort expert Dean Prosser argued that privacy was composed of 4 separate torts, the only unifying element of which was a right to be left alone. The 4 torts were, appropriating the plaintiff's identity for the defendant's benefit, placing the plaintiff in a false light in the public eye, publicly disclosing private facts about the plaintiff, unreasonably intruding upon the seclusion or solitude of the plaintiff. For additional information on privacy laws in the United States, see Health Insurance Portability and Accountability Act, Financial Services Modernization Act, 15 U.S. Code a millisecond Section 6801-6810, Final Rule on Privacy of Consumer Financial Information, 16 Code of Federal Regulations, Part 313, Fair Credit Reporting Act, 15 U.S. Code A. Millisecond Section 1681-1681 Fair Debt Collection Practices Act, 15 U.S.C. A millisecond Section 1692-1692, Drivers Privacy Protection Act, 18 U.S.C. A millisecond Section 2721 Euro 2725. Uzbekistan equals, though the right to privacy exists in several regulations, the most effective privacy protections come in the form of constitutional articles of Uzbekistan. Varying aspects of the right to privacy are protected in different ways by different situations. See also, Data Protection Act 1998, Data Protection Directive, Data Protection and Privacy Laws, Electronic Communications Privacy Act, Personality Rights, Privacy Act of 1974, Privacy Act 1988, Right to be Forgotten. References. External links, 2014 International Compendium of Data Privacy Laws, provided by Baker Hostler.